Welcome to the latest episode of Call to the Bar, International Law Over Drinks. I'm your hostess with the mostest, Tamsin Phillipa Paige, Associate Professor at Deakin Law School. Today we are discussing how we determine if something is a rock or an island, or why that matters, and why that matters in international law. I'm joined by Imogen Saunders, Associate Professor at the ANU College of Law, Governance and Policy, Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and Tim Stevens, Professor of International Law at University of Sydney Law School. Before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. But before we get down to why, to paraphrase Robbie Williams, I don't want to rock uncloss, but islands are making me feel so nice. Our traditional first question. Imogen, Tim, Douglas, what's your drink?
Well, thanks, Tamsin. I'm kicking off this afternoon with a cup of tea, but there is a potential for my drink to get more interesting because I'm working from home, as is my husband, who's a fan of the pod. And I mentioned to him that if a cocktail happened to make its way to me in about half an hour or so, I wouldn't say no. So I might upgrade my drink in a bit.
We will touch base with you if that occurs.
Likewise, I'm starting slow, Tamsin, with a cup of tea, but I hope to graduate following this podcast to a Campari.
Excellent. Douglas?
Yeah, but I'm in the same bandwagon as everyone else. I'm clutching onto my cup of tea as I try and ride out Friday for dear life. But I hope a glass of Chardonnay is beckoning in my not too distant future.
Fair enough. I, however, have made a pot of kisha from Yemen for this episode, and it's delicious. Now, Tim, while I can't speak for how you know Douglas and Imogen, we first met during my MPhil on Somali piracy at the Ansell conference in 2013, where you then invited me to give a guest lecture on the topic in your LLM Law of the Sea unit. A few months later, I was a memorial judge for you in the Australian rounds of the Jessup Moot, where the University of Adelaide team lifted a lot of my research from my MPhil for their memorials on the piracy part of the problem, but didn't cite me. And believe me, I spoke with them about that. And then later that year, you wrote a lovely reference for my Endeavour Fellowship application that funded my time at Columbia Law School. Would you like to tell the story of how we became friends from your perspective?
Thank you so much, Tamsin, for remembering those connections that we forged all those years ago. And I think it's just lovely it's lovely that you remember. And it makes me reflect on the value that we sometimes forget in the support we provide to one another as colleagues in the discipline of international law. Of course, it applies in any field of knowledge or endeavour, but yeah, that's wonderful. And the memories or the recollection that you've got very much aligns with mine. I do remember you giving some fabulous guest lectures in my Law of the Sea class and opening the eyes of students to piracy from different angles, because the Law of the Sea Convention, it's a pretty narrow kind of conception of piracy, and we don't think about the kind of economic and social cultural issues connected with piratical behaviour in places like Somalia. So yeah, thank you for reminding me of that.
My pleasure. And if you want to know more about piracy, listeners, we have an episode that we released recently on that issue.
I'm just going to leap in with a very short sidebar that will embarrass both Tim and I with the fact of our age. We first met in the rounds of the Jessup Moot in 1997/1998. So we go back at least that far.
And that was a good year for the Jessup, wasn't it, Doug? Because there was another notable Jessuper that year, among many, I'm sure. Chester Brown was in the University of Melbourne team that year. So somehow it's the Jessup that brought us together and then led to greater things.
And actually, Tim, it was Jessup that I think I first met you in as well.
Correct.
When you were coaching the Sydney team. So Jessup is something that binds many international lawyers together forever.
I must.
It's a cult. It's a cult we can't escape from, nor would we wish to.
I must confess, I had nothing to do with the Jessup until I first judged it at the memorials for you, Tim. So there you go. Right. Now, you've not been on the podcast before, so we usually start by asking new guests, how did you get into international law and what career path brought you to your present job?
So I came to international law really as a result of Jessup. I remember seeing the Jessup moot advertised at the Sydney Law School by the then coach, Don Rothwell. So this would have been in 1997. And I applied for it. Like many places, you didn't get in automatically to the team. There was a kind of selection process. And I really enjoyed the Jessup, even though the year of our competition, and Douglas will remember this well, the problem was fiendishly hard. And there was a couple of elements to it where there was just no law at all. And we were just making things up as we went along. I found that slightly frustrating. But what I did enjoy was really immersing myself in international law. And so that was 1997, 98 was my then final year at law school. And then I went on to do advanced public international law and spent a lot of time really in the company of Don Rothwell and Ivan Shearer and thought, yeah, maybe this is something I'm really interested in doing. Once I finished law school, I worked for a judge in the federal court for a year and also worked in a law firm as a commercial lawyer briefly. And some months into that job, I had a conversation with Don Rothwell and he encouraged me to think about possibly doing further study. And it was a choice between grinding hours doing banking and finance or probably equally as grinding, but more intellectually challenging and interesting hours doing a PhD. And I thought, okay, I'll do that. So that's how it kind of started. I can provide more detail if you want. There was a bit of a false start initially with my PhD. It wasn't going in a direction I was comfortable with. I ended up changing it pretty radically. But yeah, to cut a long story short, that's where it began.
Oh, fantastic. And for a note of connections in Australian international law, Don Rothwell was one of my MPhil supervisors. And for a period of time when during my PhD, I shared an office with Ivan Shearer over at University of Adelaide. So there you go, connections everywhere. But on to our main event, which is rocks and islands. So first off, UNCLOS does have sections defining legally what are a rock and what is an island. So panel, what does the law say about this, about rocks and islands, and why does it matter?
Okay, well, I'll take a first stab. So, and others can come in over the top of me. So, Article 121 of the Law of the Sea Convention, a number that will probably be found tattooed on my soul at my death, is titled "The Regime of Islands." So, it's this whole. You have other bits of the law of the sea, right? Like the regime of the high seas that goes on forever, and the regime governing archipelagic states. But then you've just got islands. And in essence, it says that an island is a naturally formed area of land that is above water at high tide. So that's a terribly helpful definition, and that such islands are entitled to the full suite of maritime zones found in the Law of the Sea Convention, the most powerful of which is the 200 nautical mile exclusive economic zone, but also the possibility of having a continental shelf rights in the seafloor that extend beyond that 200 nautical miles. However, rocks which cannot sustain human habitation or an economic life of their own benefit only from a territorial sea, and for reasons that surpass me, a contiguous zone, which is largely about customs enforcement. So if you're really desperate to stop smuggling onto a rock offshore, you have that possibility. But as I put it to students in class usually, what these provisions mean, essentially they determine the value of a piece of real estate, right? If it's an island, you've got a very valuable piece of real estate because you get this huge economic zone around it. If it's merely a rock, you just get a territorial sea and some notional rights of customs enforcement. Who wants to jump in on the back of that?
Well, happy to chime in as well. So I think Doug has very clearly explained the content of that solitary provision that insular provision almost in the Law of the Sea Convention sitting there by itself. And to put it into context, if you can think about the Law of the Sea as seeking to apply certain legal rules and principles to geographic reality. So whether it's baselines or whether it's groups of islands forming a state, archipelagic states, or whether it's isolated islands in the context of what we're discussing at the moment, it's all about trying to get the law to describe a geographical state. And Article 121 seeks to do that by creating kind of two classes of feature. So a true island has all these, as Doug put it, these additional kind of full real estate benefits, but a mere rock, it doesn't have anything other than a bare territorial sea, really. And then, of course, can I just add to that by saying there's a whole heap of other features as well that maybe don't even qualify as rocks. So, what about a low tide elevation or a drying bank, something which is only visible at low tide? So we've got all this really wide variety of bits of land sitting out there in the ocean, and we've got to try and work out the legal consequences attaching to them. And that's what the convention tries to do, but doesn't do it in a particularly comprehensive way. And that's why it has been subject to interpretation in state practice and in dispute settlement. Imogen, who's written pretty extensively on this, might want to chime in on that.
Yeah, absolutely. I think the two things I was thinking about when you were both speaking, Doug and Tim, is, the economic impact is, as Doug said, really significantly consequential. And that's especially when you consider some countries, such as, for example, France and the US, have the majority of their coastlines not on the country that you would think of as France or the US, but actually on their external overseas territories. And so, there are many countries who claim massive maritime zones all over the world, not stemming from their own sort of home territory or main territory, but rather from these various islands and or rocks. But the other thing, Tim, and I'm really glad you brought up low tide elevations, because when thinking about this, there is sort of a three-class system. You've got the islands with their full, well, it's really a four-class system, I guess, but the islands with their full maritime zones, the rocks with their territorial sea, and then those low tide elevations, and then finally things that are always buried. And where it gets tricky, I think, with, low tide elevations is whether something can be appropriated and whether it's considered capable of appropriation. And that's where a lot of the discussion has come as to what features, an actual true island, no question. But when you have something that is maybe a low tide elevation, can a country actually claim it as a feature in and of itself, which is really interesting as well.
So just for anyone listening who's not across what we mean by appropriation, so, if you're a continental state, you might go out and by right of kind of discovery or before the UN Charter era conquest, take over an island, inhabited or uninhabited, and kind of claim it as part of your own. And theoretically, you could so that's called acquiring title to territory. And it's also established that you can acquire title to a rock. So you might have, again, during the colonial period or age of discovery, gone out and done all sorts of exotic things like plant flags or screw brass plaques onto greater or smaller rocks in the world. And it could be that after the development of the exclusive economic zone, you wind up with title to a rock that's in someone else's exclusive economic zone. That's theoretically possible. But then the really sort of tricky question becomes, well, what about these low tide elevations? Can you claim them, or the tiny bits of them that kind of might still, little rocks attached to, say, a reef or a shoal in the South China Sea, or do they just belong to whatever maritime zone after the UN Convention on the Law of the Sea period that they're found in? And this obviously became an issue in things like the South China Sea arbitration. But I might be leaping ahead.
You are leaping ahead a little bit, but I do have a follow-up question on all of these different features. Now, we know that maritime zones are created by baselines, And particularly that's important when we're talking about rocks and islands for archipelagic baselines. How do rocks and low tide elevations affect baseline creation? We know that islands, that's pretty standard. They have baselines as per the usual rules, but do rocks and low tide elevations impact how states shape their baselines?
Well, the short answer is yes. And Tamsin, this is the dilemma we now face, how much detail we want to go into and whether the audience of this podcast will want us to go into Article 7 and Article 13 and tease
Let's
out
go with
all
the Spark Notes.
So look, it is pretty complex, but the starting point is that certainly rocks, there's no problem with using rocks to draw straight baselines along your coast. So there's examples. The classic example, of course, is Norway with its fringing system of rocks and islands, and Norway since the 1950s, perhaps earlier, has been using those to draw straight baselines, and that practice is then ultimately picked up in the Law of the Sea Convention, and lots of countries now use these offshore features to draw their straight baselines. Where it gets more complicated is when it's a low tide elevation, and there's rules around when you can use those for your straight baselines. But I guess the Spark Notes kind of summary is that the more substantial your feature is, the more opportunities there are to use it for drawing your baselines.
And just as a small addendum to that, I think the more substantial it is and the closer it is to your mainland, the more impact it's going to have. But again, the Spark Notes rule of thumb is, so Tamsin's talked about baselines. If you're going to say states have a 12 nautical mile territorial sea, the question is, where do you measure it from? And the ordinary baseline is, said to be the low tide mark along the shore. But obviously, very few states trace that out centimetre by centimetre. He said, making gestures that won't be visible to a listenership. But then there are rules about how you can kind of make that a bit more manageable. And that's what Tim's talking about in terms of straight baselines. So you might kind of go, well, our coastline's pretty wiggly, and we'll draw a line that follows the general direction of the coast and connects things up, like rocks and low tide elevations that are within a sort of prescribed distance of the shore. So that's where they're perhaps of most use.
Fantastic, thank you. So this question of rocks and islands came up in the South China Sea arbitration. What reading did the tribunal take of the regime of islands? And in particular, Douglas, you've claimed that they took a Global South friendly approach to these UNCLOS provisions. What approach did they take, and what do you mean by it being Global South friendly?
Okay, so I'll do a very quick summary of the importance of the rocks island thing in the South China Sea arbitration, and then I'll kind of give again the sort of Spark Notes version of what I think the tribunal was in some ways doing, and then I'd be very interested in Tim and Imogen's reactions to that. But so the short version was that obviously China has these maps in which it's drawn its 9, 10, or 11 dash line enclosing vast areas of the South China Sea. That line comes to within at least 50 nautical miles of the coast of the Philippines and takes a big bite out of what it would expect to be its 200 nautical mile territorial sea. Now, one of the arguments that might justify a maritime delimitation that was substantially less favourable to the Philippines would be, well, what if a lot of these little features scattered through the South China Sea are in fact islands that can generate 200 nautical mile exclusive economic zones? If they were islands and if they were owned by China, then you might have overlapping zones to delimit, and there might indeed be a big bite that's being taken out of the Philippines EEZ. So the Philippines was kind of clever in the way it crafted its argument. On its face, the Law of the Sea Convention doesn't let you debate who owns an island. So the Philippines said, we don't want to do that. We just want to debate whether these things are rocks or islands or low tide elevations, because if we can prove that none of these things are islands, then at best, if China owns these features, all it gets is 12 nautical mile territorial seas. And potentially, if actually all that's at issue here is sort of dumping sand on top of reefs and low tide elevations, maybe artificial islands have been built in our EEZ and we have jurisdiction over everything anyway. So if you looked at the whole sort of South China Sea dispute, if you came up with the view that nothing in dispute was an island, then actually the whole dispute became, in a sense, much simpler to resolve. And the tribunal somewhat controversially found that nothing in the South China Sea, including Itu Aba, which is an uninhabited, in common parlance, island, and pretty substantial feature, was in fact an island in law.
Can I just jump in? Do you mind,
Please.
Doug, on that Itu Aba point?
Please, Tim.
Because I've got this kind of interesting connection. It's strange, actually. So one of my colleagues at the University of Sydney Law School, Professor Emily Crawford, she was on a visit once to Taiwan, to Taipei, and she was presented by a former president, I think, of Taiwan, with a bottle of water that had been sourced from Itu Aba. And this bottle of water was given to her as proof that Itu Aba must be an island because it's got this stable source of fresh water. So every year when I teach Law of the Sea, I pull out this little bottle and I show it to the students to say, well, look, to what extent is this useful evidence of satisfying the human habitability element of Article 121? So apologies for jumping in there on Itu Aba, but I thought if I didn't do that, I might miss the chance to mention that.
Yeah. Oh, no, please. Again, I think students coming to the Law of the Sea sometimes go, this seems terribly dry and dull. I've got this 300 article multi-annex convention in front of me and all these rules seem very technical, but states take them really seriously, right? This question of, is there evidence here that would point to it being habitable by humans is important because it gets you that 200 nautical mile resource zone, which is incredibly significant. So, I mean, I've made the claim in an article that we can sort of link to in the show notes that the tribunal in the South China Sea arbitration, when it looks at the convention, has to ask itself, what is, not just what are the words of Article 121, what do they mean, but what is its purpose? And in doing that, they very significantly, to my mind, say that one of the purposes of Article 121 as it was drafted was to avoid windfalls to distant states. Now, that single phrase windfall is, I think, really important because what they're pointing to is that the convention was negotiated by real states with real interests, and there was this sort of tension over who would benefit from islands. And the tribunal pointed to a lot of kind of global South practice from Latin American and African states sort of going, well, the regime of islands was influenced by declarations, in Santiago, Montevideo, and Lima. And, there was this African States Regional Seminar in 1972 and an Addis Ababa Declaration in 1973. And we're going to take all of this into account and including, this language in the preamble to the convention that the purpose is to create, in part, a just and equitable international order. So my argument is that this sort of language and this sort of analysis sets up a kind of deserving and undeserving categories of, as it were, the owners of islands. That the point here is not that distant water colonial states should get suddenly this big windfall of an EEZ around an uninhabited maritime feature, but that the real focus was to benefit either indigenous communities or coastal communities. And so while this definition that we've pointed to talks about a distinction between human habitation or economic life, the tribunal really underscores that it's difficult for an island to have economic life without human habitation, and comes kind of close to turning the or into an and, which sometimes can happen in law, but really tries to join these things together and talks about, well, an uninhabited island, for example, or an island without permanent habitation might still have economic life if it's part of a constellation of islands that sustains traditional living practices. So it really tries to kind of narrow down who the beneficiaries of the regime of islands is meant to be. And I just find that a very interesting approach because the Global South, the Group of 77, and the movement called the New International Economic Order were actually really influential at the time the convention was drafted. But we tend to kind of lose that history when we look at the convention in the kind of cold light of textbooks now. And in my view, the tribunal to some extent rehabilitated that history, but in a way to justify quite a narrow reading of what actually counts as an island, and a reading that actually contradicts a lot of state practice. So, I mean, famously, one of the territories that's been slapped with tariffs by the Trump administration is the Heard and McDonald Islands, inhabited only by penguins and seals, but which Australia claims as an external territory and claims as fully entitled islands. And again, if you sailed past them and you asked a common sense test, does that volcanic feature with beaches and penguins and seals look like an island? You'd say yes. But if you ask, is it an island in law? Your answer might be quite different unless you're concerned with the economic life of penguins. I've spoken for too long. Tim and Imogen?
I'm happy to chime in and firstly say my cocktail did arrive. So my podcast is about to get more interesting.
Very, very jealous.
What is your cocktail?
It's look, my waiter didn't tell me, but it's a Negroni variant, I'd say. So
Excellent.
and it's delicious. Okay. One of the things that strikes me about the South China Sea arbitration, and I completely agree with you, Doug, in terms of your reading of it, but the way that the tribunal talked about human habitation, and this ties into the water, Tim's water from Emily's water from Itaabu, is the tribunal said it's not enough to sustain human life. And so they said even if a feature has water, if someone, stranded from a shipwreck, essentially, could survive on it, survival is not the same as human habitation. And really what they're looking at for human habitation is, although they didn't say you have to have evidence that it has been inhabited, the way the argument progressed, it's hard to say how you could show that a feature will be capable of support human habitation without having that past evidence, because they're talking about communities and generations and sustaining a community of people, not just keeping someone alive. And the other thing I think then with that second half, the economic life of its own, the other bit that struck me as really interesting is the tribunal were really clear to say it can't be merely extractive economic activity. And so it can't just be that you're ripping something from the island that gives it economic life of its own. And why that's important and interesting, I think, is there are islands such as the Howland and Baker Island, which the US claims, which the only economic activity was the extraction of guano. And so it's very much just a resource mining economic activity. Using the tribunal's analysis, you could make an argument in law that Howland and Baker Islands are not in fact islands, they are rocks, because they don't have that ongoing human habitation and any economic activity around them was purely extractive. But as Doug said, this is very contrary to state practice. And if you suggest to an Australian government lawyer that Heard and McDonald Islands are not actually islands, you're probably going to get a pretty negative response. So there's this tension between, I think, the consequences of some of the legal statements made in the tribunal's decision and what countries are claiming as islands currently today.
So I agree with that analysis and would add that although it's a while since I've read the 500-page arbitral award, and correct me if I'm wrong, Doug or Imogen or Tamsin, I don't recall the tribunal engaging in much in the way of a kind of global policy analysis around the implications of the various interpretations open to it around Article 121. It was a pretty narrow analysis, as I recall. And so I think that means that there are aspects of the reasoning that are a bit impoverished and which, to pick up a point Imogen's just made, seem detached from the reality of state practice. And of course, it's not just Australia, many other states, including states in the global south, to kind of pick up a point made by Doug and kind of reverse it to an extent, that there are states that are very concerned about maintaining exclusive economic zones from pretty small features, frankly, and are not happy with the tribunal's interpretation of Article 121. And I think that does raise a question for us as lawyers and people interested in the law of the sea. When will the issue next come to a head? Can we conceive of a situation where there might be another international dispute where a tribunal will need to interpret Article 121? And would they necessarily come to the same conclusion as this particular tribunal? Or will they take a different view? Now, if you may well have considered this in other episodes of the podcast, but we don't have a system of precedent in public international law. But having said that, tribunals fairly rarely depart from previous decisions, particularly really substantial ones like this. So it does raise a bit of a conundrum, I think, as to where the law will settle, having regard to the pretty fundamental disagreements that many governments have with the central conclusion of the award.
Yeah, so just to chime in on that, I'm going to hold up to the microphone so everyone can see it, to borrow a joke from Late Night Live. Stefan Talman's book on the South China Sea arbitration, where he goes into really extensive detail over 3 or 4 pages 317 to 320, about all the tiny, tiny features that states claim exclusive economic zones around. And I think one of the explanations for how narrow the tribunal's reasoning was one, they're focusing on the dispute at hand, but two, China didn't participate. And it's when you're sort of trying to make that kind of narrow argument as counsel, in this case for the Philippines, there's a great temptation just to go, oh, well, state practice is inconsistent, so you should just focus on textual interpretation, which again, in a sort of Spark Notes version, is I think what happened. And maybe had China shown up and made the argument, it could have put all that other state practice into the mix. So I think Tim's right. That's potentially a weakness of the award. It certainly helped resolve the dispute at hand very cleanly, to go, none of these things are an island. But that problem with the rest of the state practice that's out there does leave the award open to kind of challenge on how logically reasoned is it. But as Tim says, tribunals are quite reluctant to depart from the decisions of prior tribunals, even absent a formal doctrine of precedent. Imogen?
Yeah, I just wanted to jump in and say, of course, not only do we not have another case that's come up since the tribunal case, but the tribunal case was quite unusual in that China didn't participate, as Douglas said, but there was a change of administration in the Philippines. And President Duterte came in after the award had been handed down and famously dismissed it, saying it's just a piece of paper. And he wasn't going to pursue the finding because he was pivoting to China away from the US. So we don't even know what would have happened if the Philippines had decided to try and actually enforce in some way the award, what China's response would have been, whether you would have had more discussion about the decision. As it was, it just sort of faded into nothing in terms of practical terms, but left a lot of law for us all to talk about.
I think the new Marcos regime is interested in, or Marcos presidency, I should say, is interested in taking up the issue again. But the question is, how do you agitate it, particularly when you've kind of let the issue lie fallow for some time?
Yeah. So we've been talking about this human habitation requirement, and I want to kind of get your input on how does this impact upon the status and baselines of island states when we are facing climate change and rising sea levels? Because obviously that's going to impact whether or not they maintain their ability to sustain human habitation. I'll start with Tim on this one.
Yeah, so it's a really important question. And my reading of the arbitration is that the tribunal sought to find or identify the status of features at a point in time prior to any change to them. So, a constant theme in the award is that you can't turn a low tide elevation into an island. You can't turn a rock into an island. These things have a certain innate kind of platonic form existence, and we look at that, and that's a really important conclusion if you think about it, because in the context of the South China Sea, it means that China's land reclamation, which has been very damaging to the marine environment, doesn't entitle them to any new kind of rights as a result of that. So you're not creating an incentive for states to turn these tiny things into basically fixed aircraft carriers in the South China Sea. But there are broader implications of that finding for sea level rise, because I think effectively what it's saying is we look at the status quo, we look at what the feature was prior to there being any localized modification through, say, land reclamation, or potentially through global modification as sea levels rise and mean that some of these features disappear under the waves. So on one reading, you could say, well, it just fixes things in time, and even things that disappear may not lose their status. Now, that's one reading. I mean, I'm sure another view is, well, that's just artificial. Artificial in the sense of just not reflecting the reality, and if territory goes, it goes, and there has to be legal consequences for that. But yeah, that is part of a much broader set of questions now as to what the law does when geography changes as a result of climate change.
If I could add to that, one thing, I think there is a little bit of a question as to whether the idea is, or the idea the tribunal had was just to fix it in time, as Tim said, and you take whatever the status of the feature was then, or whether there's also an idea of this idea of the natural state, so the natural state of the feature. And an idea that the natural state of the feature may actually shift over time, but the important thing is you're assessing the feature itself, not what has been done to it artificially. And the reason that this is important is because the tribunal did say, when they were talking about sustaining human habitation, that the feature, in so many words, in its natural state had to be capable of sustaining human habitation. And if it could only sustain human habitation because it was being supplied by ships, or it had some other kind of artificial augmentation to it, then it wasn't actually itself capable of sustaining human habitation. Now, where this gets a bit interesting, I think, is looking at islands in climate change who might not lose their territory to the extent they disappear, but they might undergo salination so much that they can no longer produce fresh water. And we see that with the saltwater lens rising with climate change. Underground aquifers are getting more salty, and that's going to continue. And so for those islands, desalination might be the answer, but that is an artificial augmentation. So the question is, when you're assessing the natural state of those islands, which now require technology to provide human habitation, do you go back and say, well, it's what they were in the 1980s and that's it? Or do you say it's just the natural state of the feature, which right now is a feature that can't actually sustain human habitation unless there is technology providing it? There are various policy reasons as to why the first might be preferable, but I think it's still a bit of an open discussion as to what the law should actually be, because there's also reasons why saying the world is as it was in 1982 and nothing's changed might get to actually being ridiculous in terms of reality versus what the law says it is.
So I agree with all of that. And obviously those questions are very much on the mind of small island states themselves. And something I think we adverted to in passing on in our episode on the Australia-Tuvalu-Falkland Union Treaty was the fact that the Pacific Island states and the Pacific Island Forum have pushed very hard for recognition of an interpretation of the UN Convention on the Law of the Sea, where baselines, in a sense, would become permanent. They could be frozen at a particular point, and everyone would just simply acknowledge that these were the legitimate baselines of this territory, and you would continue to mark out the exclusive economic zone from that, even if particular features became permanently submerged or some islands no longer became habitable. And I mean, the law takes artificial constructions of situations all the time. That's a perfectly normal thing for the law to do. It's why we have phrases like legal fiction. I guess all I'm pointing to, though, is that, there's been this concerted effort of what we might call, in more international relations terminology, norm entrepreneurship by the states most affected by these changes to say, we can see that this could become a legal problem, and we think we should all agree a particular interpretation that prevents us, as it were, those who have done least to contribute to climate change and are now most vulnerable to it, losing out disproportionately.
Absolutely. And can I just add, though, I think the thing that makes this a little tricky to think about is we're talking about climate change as an anthropogenic process. And so in a way, we're saying, well, whatever happened to these islands, it wasn't natural. It's because humans came along and caused these emissions in the first place. But when you draw that distinction, then what happens if an island gets destroyed by an earthquake? Do we have to then say, well, that's natural and that island no longer exists? Poor people on that island. Unfortunately for you, you had a natural process happen to you, not an artificial process happen to you. But it's not even that simple, of course, because climate change increases the rates of natural disasters and makes weather events much more violent and severe. So I think it's there's lots of little strings to it. And when you start pulling one, there's always a situation where you go, oh, it doesn't quite apply here. And maybe the answer will be, as you said, Doug, a political one rather than a legal one, in terms of states agreeing that for baselines, certainly, that they're going to be fixed regardless of what happens.
I have a small follow-up question based on your comments around technology and intervention. How are we defining technology? Because at its base level, a pen and paper is a technology. So, at what point are we delimiting technological interference from natural state? I know you may not have the answer, but that's kind of what hit me when we're having this conversation.
Well, you're right, Tamsin, I don't have the answer. But, I mean, it's a really valid question, and it's certainly not anything the tribunal went to. And, of course, I think we have to remember the context, as Tim was saying. In the context of artificial intervention in the tribunal's case, they were talking about massive wild-scale dredging that was creating a runway that didn't used to be there, that turned a low-tide elevated reef into an island that hosts hangars and possibly weapons and troops. And so there wasn't really a question as, is technology being used? Because clearly it was. At what point does something become technology or not? Or does something become artificial augmentation or not? I don't have an answer to. But I do think processes like desalination, for example, would qualify, because it's taking a feature that by itself can't provide situations of human habitation and transforming it into one that does.
Look, and that's really fair. So after the South China Sea arbitration, China started making an argument last heard in the 70s, which was that offshore clusters of islands that belong to continental states could be surrounded by archipelagic baselines. What the hell is going on with that? And is that as fucking ridiculous as it sounds?
Right. So look, I'll take a first stab at this, and others can come in behind, I guess. So just to, again, row back a little bit, one of the Global South issues in the negotiation of the Law of the Sea Convention was, should there be a special regime for states that are made up entirely of islands? And there's now a whole set of provisions in the Law of the Sea Convention that says if you meet a certain mathematical formula of land area to sea area, or a ratio rather, you can declare yourself an archipelagic state, and you can draw special straight baselines enclosing all of the islands of which you are made up, because otherwise, as it were, it's a disproportionate burden to project zones from all the little features that you're composed of. And only a very limited number of states have claimed archipelagic status, and those include, most obviously, Indonesia and the Philippines. Other states that are made up of islands like Japan don't have the kind of scattered nature that would justify using those archipelagic baselines. But The thing about this sort of regime of islands question was there were plenty of states that had offshore clusters of islands that were very significant to them, who also went, wait a minute, shouldn't we be allowed to draw straight baselines around our little archipelagos that belong to us? So Greece is the classic example here, right? You know, a state with a continental mainland, but also made up of lots of islands. But the conclusion of the UNCLOS negotiations was only states that are exclusively made from islands get to use these very beneficial straight baselines and then claim that the waters inside them have a special status. Now, having ostensibly lost the South China Sea arbitration, not that China accepts the arbitration was legitimate or that it was bound by the results or that the results were legitimate as a matter of legal reasoning, nonetheless, suddenly this, what's called the Four Shahs claim, re-entered public discourse. Now, the Four Shahs are 4 island groupings in the South China Sea that are of significance here. The Pratas Islands, the Paracel Islands, the Macclesfield Bank and Scarborough Shoal taken together, and the Spratly Islands. Or if I can mangle the Chinese, the Dongsha Kwando, the Sisha Kwando, the Zongsha Kwando, and the Nansha Kwando. So the idea here is that each of these clusters of features should be allowed to be treated under a special rule of customary international law as a single legal entity or outlying archipelago. You then draw great big straight baselines around them. You get to project 200 nautical mile zones from them, and voila, suddenly you own enormous chunks of the South China Sea. There are multiple problems with this argument, starting with the fact that most of these features just don't qualify as islands even to begin with, right? We're talking about tiny, if we think about the Spratlys, it's over 140 features, and the 13 largest have a total area of less than 1.7 square kilometers. So these are not credibly archipelagos to begin with. Second, this was an argument that China made in the Law of the Sea Convention negotiations, and then seemed to abandon because it wanted to be seen as aligned with the position of developing states that took this view that only archipelagic states should get this rule. More worryingly for me, though, it's what I call a sort of strategy of legal fragmentation, which is to say the Law of the Sea Convention is not comprehensive, step 1. Step 2, it therefore contains gaps. Step 3, we can fill those gaps with special rules of customary international law. Step 4, look, we've found this customary rule about outlying archipelagos and it benefits only us. And I think that risks the fragmentation of the Law of the Sea Convention as the constitution for the oceans. But that's my sort of Spark Notes version of what's very often called the Four Shahs claim as presently put forward by China after the South China Sea arbitration award.
And well explained, Doug, and I agree with you. And look, if they are archipelagos or can justify archipelagic straight baselines, then let's go the whole hog and call Australia an archipelagic state. And we can draw straight baselines out to Tasmania and Lord Howe Island and Norfolk Island and Cocos and Keeling Islands and Christmas Island. No, it's patently ridiculous. And you've raised, or just before I get to that point, kind of just, you noted that there are not that many archipelagic states, which is correct. There's only 22 of them, as I understand it, or at least that's what Rothwell and Stevens say in our International Law of the Sea book. And they're all in the global south.
This is why we have you here, Tim.
They're all in the global south, and I'm holding that up for everyone to see as well if they wish. Yeah, so relatively small number of states. But coming back to an observation you made, Doug, which I think is really, really important, and it's one that we're increasingly confronting now as the convention reaches its middle age. You know, it was drafted or concluded in 1982. We're now 2025, and although the convention's very extensive, and many would say comprehensive, it's not exhaustive. And we're starting to see areas of the convention, where there are questions, there are doubts, there are uncertainties, and we need clarification. And how do we get that? Well, we can get it through the kind of classic practice in international law of states making assertions and then seeing what other states do in response, whether they protest those assertions or accept them. And some of that practice, in the South China Sea context, for instance, is not necessarily productive. And I share your views around the baselessness of China's claim. But on the other hand, we are starting to see some pretty positive practice. And I would put the practice of South Pacific states in that category, because I think the way that those states, including Australia, have sought to make a constructive contribution to interpreting provisions of the Convention in relation to baselines and the permanence of maritime zones in the face of sea level rise. I think that's an example of really useful practice to try and bring more sense and meaning and, frankly, consensus around important provisions of the Convention.
Well, I'm going to just say for some really interesting work on archipelagos and the archipelagic state, I'm going to give a shout out to Alex de la Cruz, who's been a guest on the podcast in one of the Roadshow episodes. He's doing some really fantastic work. I know his doctorate was on the construction of the archipelago as a legal idea. So check out his work. And now, in wrapping up, we usually ask a non-international law question, and in season 2, we're asking our guests, so in this instance, Tim and Imogen, because even though you're a co-host, you haven't answered this question yet. Who is one of your favorite obscure or underrated characters in fiction, and why did they speak to you? Douglas, you don't get to answer again. I don't make the rules.
Well, I'm happy to go first at this one. It was interesting thinking about this afternoon because it made me reflect on my reading practices, because I realized I think read for narrative rather than character. And all of my favorite characters are unsurprisingly often the main characters in the book. And it took me a while to try and think of a character that was underrated or obscure. But what I came up with was there's a children's book called Goodnight, Mr. Tom by Micehlle Magorian. It's a classic of the genre. I cry every time I reread it. And it's about a child evacuee who gets sent to the country from London during World War II. And he gets boarded with a grumpy old man who he calls Mr. Tom. And his living situation in London's pretty horrific. And essentially throughout the book, both he and the old man grow, and there's a lovely touching bit at the end where they become a family. But in the course of this, when he gets evacuated to the village, he's sent with no clothes. Only the clothes he's wearing and nothing more. And so Mr. Tom goes and organises from the local shop to get him clothes. And what I've only realised as a parent and as a knitter is this local shopwoman who gets treated with a bit of disdain somehow in the course of a week produces not only trousers and shirts and socks, but also knits an entire jumper and a balaclava for this child. And no one seems to treat this as remarkable, which as a knitter, I can tell you it's taken me 5 years to knit a jumper for my son and I still haven't finished. So I like to think that this woman has knitting superpowers and the village just takes it as normal that this is what happens.
Fantastic. Tim?
Well, given the topic of today's podcast, I started to think about the various books I've read over the years, works of fiction about islands and some of the characters in them, whether that be Lemuel Gulliver in Gulliver's Travels, or of course Jim Hawkins in Robert Louis Stevenson's Treasure Island, or Robinson Crusoe in Robinson Crusoe. But the character I settled on is not actually really an underrated character, but I like to think I identify with aspects of his character, and that's Ralph in Lord of the Flies. William Golding's brilliant book in 1954, and I'm sure all the listeners know this book, and if they don't, they really should know it. I mean, William Golding was, an interesting character. He did win the Nobel Prize for Literature, and certainly aspects of his writing would not be considered politically correct now, but Lord of the Flies is such a visceral novel that speaks to aspects of the human character, which I think hits home to some extent. And the character that I like to think identifies Ralph, who's seen as the kind of the natural leader on the island and seeks to maintain order and civilization. He goes off and tries to get the boys to build huts. Of course, it all falls apart. The boys start fighting viciously and violently, and the whole thing turns to crap. But at least he tried. So yeah, that's the character I thought I'd mention.
Fantastic. And finally, Douglas, tell us about today's outfit.
It's a relatively casual Friday. I'm wearing a pinstripe flannel suit, a blue and white striped shirt with blue braces, and a cardigan from Muji. But I am wearing, talking to Imogen as on the making of clothes, I'm wearing a floral blue bow tie that I sewed myself. And as a novice sewer, the idea that you could produce an entire wardrobe of clothing for a child in a week, again, I think feels like it bespeaks superpowers.
Fantastic. Well, that's all we have time for in this episode. Thanks for listening, and we'll catch you next time. Bye-bye.
Goodbye.
Bye.
Bye.